We're in Austin, Texas today with Texas Land Commissioner Jerry Patterson. Commissioner, welcome to Breitbart, Texas.
Good to be here again.
Good to talk to you again, sir. And it's an interesting dispute that we have going up in North Texas. I spoke with the Bureau of Land Management this afternoon, and they said there is no land grab underway because they've owned this land since, they want to say the beginning of time, but basically back to the Louisiana Purchase type of thing. So let's talk a little bit about that claim of theirs and how that came about.
Yeah, you need to have a little background. First of all, under virtually all laws going back to Roman times, when rivers move, boundaries change, ownership changes, and that's accepted law, and no one disputes that. The dispute comes a little later, but we have three legal principles having to do with boundaries against bodies of water, and they are erosion, accretion, and avulsion. So this boundary, which was set at the south bank of the Red River by essentially initially in 1819 in the treaty between the Kingdom of Spain and the United States of America, and then later by Supreme Court decisions, is the south bank of the Red River, and we're really not disputing that. But that south bank of the Red River, as we know, it moves. Rivers move, particularly rivers that meander, such as this one. But under the law, gradual movement, such as occurs when you erode, i.e. the property washes away gradually over time, or when they accrete, i.e. the property through sedimentation and and more deposition. When the property accretes, the boundary moves. Now, erosion and accretion are gradual processes,
right? And
that's accepted under law. We all know that erosion and accretion change ownership, change boundaries between states and nations. But the exception is avulsion. Avulsion is erosion that occurs dramatically, essentially a flood, a catastrophic flash flood. Avulsion does not change boundaries under riparian law, and this is river law, which is called riparian law. The question arises, though, is that at one time we knew that the boundary was what is the south bank, and this is a map of some of the area in question, and it's actually the Texas bank, if you will, which is the south bank, although the river meanders around, and right here it's running north and south. So
for our readers' perspective, this is north.
That's correct. So the south bank, we're calling this the south bank, even though it's in a westerly direction. So the river is no longer, the bank of the river is no longer here. The bank of the river is over here somewhere. Okay, so question becomes, did it move by an avulsive event, or was it a gradual erosion event? Now, that's a very important question. But the bottom line is, the BLM always assumes that it's avulsive and when it works to their advantage, or that it's erosion when it works to their advantage. And in our view here at the land office, you got to prove it. You just can't say, we call this avulsion. We now own that. It's a matter of proving it up, which would require an on-the-ground survey, a very expensive, very lengthy, 116 miles of riverine frontage in question survey. You just can't come along and say it's mine. And it's also unique in that normally when you have a river, for example, there's a Green River boundary with Louisiana. Texas owns to the middle of the river. Louisiana owns to the middle of the river, from the opposite bank. This is different because of that 1819 treaty between Spain and the United States, which set the boundary on the south bank of the river. So along comes Texas becomes a republic, Texas becomes a state, Oklahoma becomes a territory, Oklahoma becomes a state. And so Texas boundary still goes up to the south bank, and then on the north side of the south bank, the riverbed itself, the Indian nation has an interest, and the state of Oklahoma has an interest. So as it is, we all agree, the state of Oklahoma has a northern half of the bank, from their bank to the middle of the river, and that southern portion is titled to the three Indian nations, and it's managed by the Bureau of Land Management. So the BLM does have an interest in this riverbed, and it's unusual that they do, but they have an interest because of the 1819 treaty between Spain and the United States. But the BLM is asserting that all of this that's occurred was an avulsive event. Now, you have, in my view, and I'm not an attorney, you have to prove that up. You just can't say, well, this was avulsion, it is now mine. Since avulsion doesn't move the boundary. So what happens now is that this southern bank, the adjacent property owners, when that river moved, they assumed their title went to the riverbank. And it certainly would have had that river moved under a slow process such as erosion or accretion. If it moved by avulsion, then there's some question about it. And the problem is, I see it, the BLM assumes everything's avulsion. And so we're going to have to prove that up. They're going to have to prove that up if they're going to claim title to this land.
Now, today on the phone with them, they mentioned that that they have failed basically to manage this land over the
well, I kind of like their failure, frankly. I mean, you know.
So why are they?
Why do they need to manage the land? The land
right.
is being managed by the private property owners. I mean, the private property ownership is the best stewardship of land in almost all cases, and obviously there are exceptions. You know, parks is a good use of public land. You know, military installations, but private property ownership. This land has been grazed. It's been maintained. Taxes have been paid on it by the owners from Texas, and for that matter from Oklahoma. But I have to caution people, just because you paid taxes on it doesn't mean you own the land. I mean, you can pay taxes on whatever. The county's going to take your dollars. They're not going to say, "Oh, I'm sorry, you overpaid us." So paying taxes alone does not prove anything. What is in question here is how did the river move? Did it move by, in this case, accretion of the south bank and erosion of the north bank, or did it move by a cataclysmic avulsive event? And you just can't deem something avulsive without proving it up.
Now, obviously, this has large impact on some families that live up here, the Henderson family and some of the other farm owners up there. But the state of Texas also has interest in here as well. Is that correct?
We do, and you know, normally we would have interest in the southern half of the river, but since we don't, because of the 1819 treaty, before Texas was even a republic, when we were part of Spain, we don't have an interest in the riverbed like we normally would. But we do have, along this 116-mile stretch, we have some surface ownership, we being the Permanent School Fund. We have some mineral ownership as well. So we have we believe, a standing in anything that's decided on this river frontage, because we have minerals. They're constitutionally dedicated to the Permanent School Fund. We have surface acreage. We have fee ownership, and we intend to defend our ownership in whatever manner we can, which is obviously the courts.
Now, General Abbott yesterday basically drew a line in the sand, if you will, and said he was going to plant the flag there and say, "Come and take it." But realistically, this is not going to be something like the Henderson, the Bundy Ranch out in Henderson, Nevada, where you have police officers out there basically trying to evict people off of land.
I can't see that happening, but you know, first of all, that incident in Nevada, Bundy is wrong. You know, that land was, you know, it was owned by the federal government before Nevada was a state. Bundy's wrong in that case. In this case, I don't think it's that. It's not the similar circumstance at all. This is a issue of where does the moving boundary lie. Now, I've heard people say, well, you know, you got a patent or you got a title and it's surveyed and you got this. Yes, that's true, but on all patents, on all titles that abut a body of water, you've got a definitive survey on 3 sides. And on the 4th side, whether it's the Gulf of Mexico or whether it's a river, the call, which is the survey term, is to the waters of the river or the bank of the river, or the call is to the waters of the Gulf of Mexico. So it's survey, normal survey, patents, titles, all call to the water. And not the water as it existed at the time of the conveyance, but the water as it exists on a daily basis. So accretion and erosion, you can gain title to property and pay no one anything. I mean, if this was as we believe, it was a accretion, a gradual growth of the land, then this Texas property owner would gain title to that, and he would owe nothing because this boundary moves. If it was an erosion event, gradual loss of the sediment on the bank, that owner would lose title, and no one owes him anything. It's the same thing as on the Texas Gulf Coast. If you're
just
land,
the risk of owning property along a waterway.
Exactly. It's the risk of owning property adjacent to a dynamic body of water, like an ocean or a gulf or a river that meanders like this one does.
Now, Commissioner, what's the process here? The BLM is doing this study. I don't think there's an imminent decision.
I don't think there's any imminent decision, and we're going to make sure that that's not the case, because you got 116 miles of survey to do on the ground, LIDAR. You know, it's not just going to be, again, like I said earlier, waving a wand and say, all of this was a Vulcan, therefore we win and you lose. We're not going to let that happen.
How do you prove something that happened, like this flood that came through here was over 100 years ago?
Yeah, I think it was it in the 20s or the teens? It was a long time ago. So how do you prove up that that was an evulsive event?
Right.
I mean, do you have any first-hand testimony, first-hand evidence? I mean, do you have someone that was there and saw it? You know, I think it's going to be difficult for them to prove that. And they're, in my view, they're going to have to prove it. You just can't deem this to be the circumstances on the ground. You got to have proof.
So the burden of proof would be on the party trying to claim the land.
We're sure as hell going to try to make it that way.
Okay. 116 miles, we're not sure if that's river miles or crowfly miles, basically.
We weren't sure if it's a point on the river is not a straight line river. Anybody that's looked at a map of Texas up there, you can see that river moves around. So
it's part of the iconic shape of Texas.
Yeah, it is. We think that's river frontage miles, but we can't tell for sure.
Okay. Are you having any direct communication with the BLM on this?
Yeah, we've talked to them several times. We've been asked to be part of their scoping process, and we've, you know, obviously said we want to do that. Several other agencies have asked for, you know, to be part of the scoping process, and I know Congressman Thornberry's on top of this, and we're going to need congressional help on this, so I'm glad he's weighed in big time. We're on top of it. The Attorney General is obviously looking at it. But, you know, we have standing here, we being the Permanent School Fund, the Texas General Land Office, because we have property at risk because of our surface or mineral ownership.
Okay. And Senator Estes and Senator Duncan talked about a partnership agreement with the BLM or something along those lines. Is that something that we would enter into with the federal government to say, okay, Texas will manage these as a partner with the federal agency? Or?
Well, I don't want to do that. I just think this is private property in Texas. Nor the BLM nor Oklahoma need to manage it. I think, you know, assuming we prevail and assuming the private property owners prevail, the best and highest use of land is in private hands. I mean, there are exceptions, you know, national parks, etc. But land has been grazed. It's been hunted. It may have been farmed and, you know, may have been tilled. There may be some mineral ownership in play here, royalties, things of that nature. So I don't see any need to partner with the BLM. I don't see any need for the BLM to partner with us. I mean, it's not, I'm not slamming the BLM here. I'm just saying, let's let the private folks take care of it.
Now, the way the BLM explained it to me today, they saw perhaps 3 possible outcomes of this. One would be, you know, much of this land is landlocked. They can't say, okay, we're going to open this up to be a horseback riding area because there's no public access.
You've got to have an
this
access
land.
point. You could open it up where there's a, you know, a public easement such as a bridge abutment maybe, but you can't just walk across somebody's or ride your horse across somebody's property to get to the river. No.
So they were saying basically that they may decide that that they're going to abandon the land because they can't manage it. They can't get to it to manage it. They might, in which case they might sell it or some other way dispose of the land.
I don't see, you know, if it's not theirs, and again, they have to prove up the circumstances. I don't see how you can sell something that doesn't belong to you.
Yeah, it seems like all 3 of their scenarios involved exactly that. It's their assumption that that whole 90,000 acres has and always will belong to them.
Yeah,
and
that's, you know, that's they can't possibly say that because wherever the boundary is today, it may be somewhere else tomorrow. And this is, again, you know, when you have property adjacent to a body of water, whether it's a river or an ocean, that boundary moves and you lose or gain property. That's because that survey was surveyed to the banks of the river or to the waters of the Gulf of Mexico or the Atlantic Ocean.
So where do we go with this? I mean, what is the process now for Texas?
Well, I've got probably about 4 people working on it here at the land office, attorneys, survey, or our director of survey, and we're going through court cases, and we'll do whatever we need to do. And obviously, we want to cooperate with the BLM in the resolution of this. but cooperation does not include just being told, trust me, this is mine. That's not cooperating. And I wouldn't think, and if I were to do that to the BLM, I wouldn't expect them to believe me either. So, you know, we're going to do what we've been doing for about the last 2 or 3 weeks. When this was first brought to my attention by Senator Duncan and Senator Estes, I wasn't aware of it. And then, of course, the Bundy thing made a big splash, and now we're trying to, you know, and we don't need a bunch of people running up there and waving, come and take it flags. That's not going to help anybody. I mean, you have the opportunity to make press. I mean, you can wave all the come and take it flags you want, but none of that means anything until we have a bona fide, on the ground, very expensive, very lengthy survey of 116 miles of river frontage.
How long would it take to do a survey like that?
It'd be a couple of years. I mean, yeah, depends on how many resources, how many survey teams you get out there. And since they're wanting this land, I'm not spending my money to survey it. It's their action that they need to prove up. That should be their expense.
Okay. Governor Perry today basically said this is the entire wrong discussion to be having, that instead of talking about the federal government increasing their land ownership, we need to talk about decreasing federal land ownership. But in Texas, we don't really have much of a problem with that. BLM doesn't own very much land in Texas.
Well, you know, frankly, no government entity owns much land in Texas. I would say about 95% of the surface acreage of Texas is privately owned, and that's because, unlike Nevada, or New Mexico, or Colorado, or Wyoming, we entered the Union by annexation treaty between two sovereign nations, and we retained our public lands and our public debt. Normally, the federal government would have assumed your debt and assumed your unappropriated public land. That's the way it happened in Nevada. We didn't do that. We kept our debt and kept our land. We didn't, actually, kind of interesting, we wanted them to pay off our debt, but they wouldn't do it. Okay, fine, we'll keep our land. Turned out to be a pretty good deal in the long run.
Yep, it did indeed.
Yeah.
So, well, thank you very much for your time and
You're
talking
welcome.
about this and your attention on protecting the rights of our private property owners here in Texas, and the interest of the state of Texas in the school fund, so the permanent school fund.
Yeah,
So.
it's you know, just another day at the office.
All right. Well, thank you very much.
Thanks, Bob. All right, appreciate it.